He was selected by Forbes magazine for the 30 under 30 in law and policy. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. He is an adjunct scholar at the Cato Institute. He is the founder and president of the Harlem Institute, the founder of Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, and blogs at joshblackman.com. He is the author of nearly 5 dozen law review articles, and his commentary has appeared in the New York Times, Wall Street Journal, Washington Post, USA Today, LA Times, and other national publications. So now I'll pass it off to Professor Josh Blackman, who's going to give us a really interesting and engaging presentation.
I hope so. Thank you, Eric. Cornell, it's good to see you. I was in Ithaca. Was it last March or April? I can't remember what it was. It was in October, wasn't it? I was in Ithaca last year. I can't remember exactly when, but I was there. It was my first time there, and I very much enjoyed it. You know what? It was not freezing cold. So I think it was like still quite October. It wasn't quite that cold. But I enjoyed my trip. It was my first time there. And Professor Mike Dorff and I, we did a debate on the Obamacare litigation, which is going to be argued on Tuesday. So things seem to just never quite change. We're always in the same topics over and over again. If you heard my little spiel at the beginning, I do want to take this seriously. I know Zoom University is not designed for happiness, and it can be a very dark place, especially when you're sitting in front of a computer all day. So to the extent you can, seek help. And I'm not here to preach. I'm not yelling at anyone, but we've had too many students who have had issues already in my own school. And I'm sure there's students at your school who have similar issues. So you're not alone. And I mean that sincerely. And I can help you. I'd be happy to help you. If you want to call any professors, they'll take your call anytime. All right. On a happier note, let's talk about the Supreme Court. When Eric first invited me to come, to visit Cornell, the Supreme Court had a very different feel to it, right? It had just finished a term unlike any other. We had Chief Justice Roberts preside at an impeachment. We had a shutdown because of the pandemic, all in the span of 2 months. And we had big cases on guns, abortion, DACA, contraception, gay rights, tax returns, and everything. This was a tumultuous term. And it was a term in which Chief Justice Roberts asserted himself, unlike perhaps any other Chief Justice in modern history. He was in the majority in almost every single divisive case. And in almost every big case, he decided the outcome. It was looking like Chief Justice Roberts was the new Justice Kennedy, that he was going to be the deciding vote, and he had all this power. But then things took a change on September 18th of 2020. In the midst of the pandemic, the presidential election, Justice Ruth Bader Ginsburg passed away. And that really changed, I think, the future of the Supreme Court in ways that we don't quite appreciate. So what I'd like to do now is take a look back at the October 2019 term. And then consider what's happened over the past 2 months since RBG has passed away. And then I'd like to look forward to the October 2020 term, which is underway right now, and talk about some of the high-level issues. I also want to talk about the election and what the Senate majority likely means, and the election majority likely means for the future of the court and how many members it has. All right, so let's start way back when, October of 2019, feels like a lifetime ago. The Supreme Court heard arguments in a very significant case called Bostock v. Clayton County. This case considered whether Title VII of the Civil Rights Act of 1964 prohibited discrimination on the basis of sexual orientation and gender identity. For nearly 5 decades, virtually everyone agreed that the answer was no, it didn't. But Justice Gorsuch, who says he's a proud textualist, struggled with the case. And he struggled for a textual reason. He said, well, in order to discriminate against a person because of their sexual orientation and gender identity, sex is a necessary ingredient. right? This phrase "because of sex" has to apply to any type of LGBT discrimination, and he seemed leaning in that direction during the arguments. And that was the first hint that this term would be a term unlike any other. Fast forward to November of 2019. The biggest case on the docket that month was the DACA case, the deferred action case for the Dreamers. You may recall that President Obama in 2012 announced this policy that protected from deportation certain young immigrants, and it granted them certain benefits. This was challenged in court, but the courts never stopped the DACA policy. But after President Trump came into office, he eventually decided to rescind it, to wind it down. That effort proved unsuccessful, and court after court argued that no, you did not justify the rescission. You didn't do enough to cancel it. Some courts actually held that President Trump had an animus, a hostility towards Hispanics, and that tainted his action. I wonder if we could look at the exit polls of how Trump did with Hispanics to affect those analyses, but we'll put that aside for a minute. Yeah. Who the hell would have thought that after 4 years of all this insanity, he would actually increase his share of Hispanic voters? What a world. Then we go to December. And in December, the biggest case involved guns. Yes, the Supreme Court had not decided a Second Amendment case in more than a decade. We had two cases back to back. We had Heller in 2008, which held that there was a right to keep and bear arms. And then in 2010, we had McDonald, which was a case from Chicago, where the city's handgun ban was declared unconstitutional. But that was it. And in the last decade, there was just no appetite for the Second Amendment. So for the longest time, gun rights advocates wondered, who is it? Who's holding this up? Is it Kennedy? Or is it Roberts? I always thought it was Roberts. I was never really sure about Kennedy. Kennedy's a little bit more, he likes liberty in its manifold respects. And Roberts seems more, he's afraid of everything. Don't put him in groundhogs. He'll see his own shadow, he'll run away. The chief finally, apparently, found a gun case he liked. And it came from my hometown of New York City. I'm from Staten Island. New York had this insane law, which said that if you want to transport your gun from one house to another in a locked container, you need a special permit, which you're not going to get, right? So basically, if you had two houses, it was virtually impossible to move your gun from place A to place B. What if you wanted to transport your gun to New Jersey or Pennsylvania where there was a gun show or a shooting range? You couldn't do that. You had to use a gun range in the city. So let's say you lived in Staten Island, which is my hometown, and there's a gun range 5 minutes across the bridge in New Jersey. You could not go there. You drive all the way out to the Bronx to go to a gun range, right? This was a very burdensome law. And putting aside the Second Amendment, it was probably irrational, right? It made no sense. Why did you need a permit to go to a range in New Jersey, but not 5 minutes, 5 minutes away to New Jersey, but not, to Bronx 2 hours away? All right, so what happened here? After the Supreme Court granted certiorari, New York did everything in its power to moot the case. The city repealed the statute, and then the state passed a law making it impossible to reenact the statute, right? This is like a textbook execution of the mootness doctrine. They did everything they could to moot it. So then the question became not whether the gun ban was constitutional, but whether there was also a live case or controversy on the docket. And there was some pressure. Senator Whitehouse and other Democratic senators put in an amicus brief, and they said, hey, Supreme Court, 9's a good number, 11's better, right? If you guys find this case is not moot, guess what? We're going to need to restructure. That's what we use. Restructure your court, which means add a couple seats. So this was the first hint that, they weren't playing around with court packing. This was just sort of, you're putting this in a SCOTUS brief, right? So it didn't look like we get a ruling on the merits. Okay, now we go to January. In January, the president was impeached. I mean, I know that feels like a lifetime ago, like it never happened. In the entire election season, how often was the impeachment mentioned? I think never. Did it ever come up in any debates? Was it ever even brought up in any of the DNC speeches? It's like it never. We had an impeachment, my goodness, and it never happened. It's like whatever. But Chief Justice Roberts had to pull double duty. In the morning, he would hear arguments at the Supreme Court, and he would say to the wee hours of the night, presiding over the impeachment trial. I criticize Roberts a lot, but that's an impressive feat of strength. I don't know how many people can endure that sort of marathon session, be fully prepared. But he was up to the task. I think he did it quite well. Roberts didn't really do much, though. At one point, he criticized some of the senators who were being a little too partisan. Roberts said he would not break a tie vote, which could have been significant. Not that we had any tie votes, but he refused to break one. Roberts seemed to frustrate people on both sides of the aisle in the Senate, much like he does in the court itself. He seemed to just annoy everybody. Finally, in February, we had a verdict, 52-48. The president was acquitted. Only Senator Romney crossed the aisle to vote to convict the president on one of the counts. But by February, we started learning about this thing called COVID. COVID, right? COVID. I'll speak personally. I didn't take it very seriously in January and February. I didn't think it would matter. It wasn't on my radar, things that would become significant. But very soon, it became apparent that this would affect all of our lives, and even the Supreme Court. The Supreme Court held its last round of in-person arguments on March 3rd and March 4th. March 3rd was the case Sela Law versus CFPB. This was a challenge to the structure of the Consumer Finance Protection Bureau. And the next day, March 4th, the court heard arguments in an abortion case in Louisiana, June Medical Services versus Russo. This law challenged the so-called admitting privileges regime. Louisiana required doctors to gain privileges to practice in nearby hospitals. And they argued that this, this requirement had no benefits to women and instead imposed an undue burden on the right to an abortion. March 4th, things still seem kind of normal. I remember I went to my last FedSoc talk. It was March 11th. It was at the University of Oklahoma in Norman. We all had lunch together. No one was wearing masks. I shook everyone's hands. We had an event at the school. We passed around sandwiches. We were all sitting and chatting. I rode in a taxi on the way back to the airport. The woman next to me in the plane had a mask, and I was like, what's wrong with her? Why is she wearing a mask? What's wrong with her? Yeah, that was funny. That was March 11th. And, by the end of that week, it seemed like the world just stopped. The NBA canceled games in the middle of the evening. Tom Hanks tested positive for COVID. Institutions shut down. And the next week, the Supreme Court shut down. The court had not shut down for pandemic in some time. They shut down for the Spanish flu of 1918. And before then, the 1790s, the court shut down for the yellow fever influenza. It's not influenza, the yellow fever outbreak in Philadelphia. Among other things, Alexander Hamilton got a bad bout of yellow fever that year, so it's serious. But the court shut down and they canceled all 3 March arguments. Query one point, the ACA case that is going to be argued in March of this year, argued next week, had the court not canceled those arguments, there was a chance that it would have been argued last year. And I want to just put in perspective, Fulton, another case I'll mention about religious liberty, that probably would have been argued last year, maybe, not necessarily, but may have, which would have meant that Justice Ginsburg would have been on the cases for Fulton and for the Obamacare case. So the decision to cancel those arguments and push them ahead to the next term probably, at the time, changed the bench of who would decide those cases, which may prove significant. Look, if I would much rather have Ginsburg on the bench for a religious liberty case than Amy Coney Barrett if I'm the city of Philadelphia. I'll just leave it there. I think we're all agreeing on that one. Eventually in April, the court started just issuing orders without actually coming into the court. It was just sort of like, we put a PDF online. That's how we do justice now. We PDF it, right? The first big case they had involved COVID. And Wisconsin. there was a challenge to absentee ballots in Wisconsin, how late they can be accepted. The lower court had permitted extending the ballot. And by a 5-4 vote, the court reversed that and said, no. Federal court should not be intervening with these late changing deadlines. All right. Later in April, the court decided the gun case, the New York pistol rifle case. The court dismissed it as moot, as I think was probably the correct remedy. Justices Alito, Thomas, and Gorsuch dissented, and they were pissed. And they were actually mad at New York for manipulating the docket to try and get a case mooted out. I think they were absolutely correct. Justice Kavanaugh concurred and said, well, this case is moot, but, we can take another case. There are lots of other gun cases in the docket. Let's take another one. So that's at the time I thought, maybe Kavanaugh knows what he's talking about, right? Maybe he realizes that there's so many other gun cases in the docket that, all right, fine, this one goes away, we get another one next term, whatever. All right, whatever. So Kavanaugh knows what he's doing. Then we get to May, and the court finally announces that it would hold oral arguments. No, they're not going to use Zoom. That would be too cool. Instead, they use telephone. And they do it in the most boring fashion possible. In order to avoid the justices talking over each other, because they can't see each other, each justice would get a few minutes to talk, and then they'll go to the next justice in seniority, and so on. So you start with the Chief Justice, then you go to Justice Thomas, who's most senior, then it would be Justice, it's Justice Ginsburg, isn't it? Was Justice Ginsburg, then Breyer, and so on down the line. And then eventually, after everyone has questions, they can go back for a second round. That never really happens. The chief was supposed to keep time, and I can tell you he did not do it well. He gave some justices more time than others. There are some studies upon this you can read. I've noticed that he gave Justice Alito a lot of time, because I think he wanted to know what Alito had to say. And apparently he cut off some of the female justices. You can go read those studies. But the chief was not very good with time on this one. Perhaps the most embarrassing moment, though, came during an argument in a case called Barr versus AAPC, American Association of Political Consultants, where during the middle of the questioning, I think Justice Sotomayor was asking questions, in the distance you hear this flushing sound. And one of the justices had forgotten to mute his phone when she went to the bathroom. If you believe the cyber sleuths, which I find credible, it was Justice Breyer who did the deed. That never happened again. But several of the justices made the same mistake you all make, and they forgot to take themselves off mute. So a couple times, apparently, Justice Sotomayor was asking questions, and then no one heard it. And she's like, "I'm sorry, Chief, I did it again." She apologized for it. They're human, right? And I kind of like it. Like, we've all been there, right? We've all heard on Zoom people flushing, right? We've all heard on Zoom people muting themselves. They're human. They're not these demigods. Although they pretend to be, but they're not. They're humans. Even Justice Thomas became a regular questioner. He hadn't asked questions in years. He would go a decade without asking a question. And in one case, in the tax return cases, he asked more questions than he'd asked in the previous 14 years. The thinking goes, and a couple of the Thomas clerks have said this out loud, Thomas doesn't like fighting with his colleagues for time to argue, right? They're always jabbing each other, interrupting each other. And Thomas is pretty mild-mannered. He doesn't want to have to argue and fight with his colleagues for precious time. So he's like, screw it. I'll just let my colleagues put on a show. But now that he has a dedicated 3-minute set, he will actually use it. Indeed, there was a case argued yesterday, or I guess on Tuesday at this point, called Fulton. No, it was yesterday, Fulton. And at one point, Thomas said, I have no questions. And he just passed. Can you imagine? He just passed it. I have no questions for the Solicitor General. I got nothing. I'm a rule from anyway, so it doesn't matter. They pass. But good for CT. In May, the court heard several significant cases which they had to decide. One case involved the Little Sisters of the Poor. Yes, the poor nuns. They keep coming back to the court and they never get anything. This was the latest iteration of the Affordable Care Act's contraceptive mandate litigation. The latest iteration. In this case, President Trump tried to wind down the Obama-era policy. And surprise, surprise, federal judges issued nationwide injunctions saying, no, you cannot stop what Obama created by executive action through executive action. You have to stay with the Obama policy because you have not adequately justified your decision. Okay, we've all heard that before. As a result, the Obama policy would remain in effect. The next big case, though, involved the president's tax returns, which, again, we made it to another election, and we still don't have the damn tax returns. I mean, just pause and think for a minute, right? We've had 2 presidential elections with I don't know how much litigation, and we still haven't seen the documents. I mean, the New York Times has them. They just won't release them. Maybe we should get an injunction from the New York Times to release the documents. That'll be easier. We don't have these documents. But there were 2 cases. One by the New York District Attorney, Cyrus Vance. The second was filed by several committees of the House. They submitted the exact same request for documents, which is a huge coincidence. They had the exact same request. Things, great minds think alike in Washington and New York. And they argued that they needed these documents. In New York, they argued they needed the documents for a grand jury to investigate unspecified crimes, and we still don't even know what those crimes are after the election. We may see indictments, though, if Trump loses. That's just, it looks like he did at this point, but we'll probably see indictments from New York at some point because that's what we do to former presidents. We indict them. That's where we're going with this. The House case, they needed the tax returns for so-called legislative oversight. They needed to consider different types of legislation, and the tax returns would help them. Okay. All right. That was a tax return case. Then we get to the end of May, and the Chief Justice decides a case called South Bay United Pentecostal Church versus Newsom. This was an appeal from California, where a church, a Pentecostal church in California, challenged the governor's COVID order. And they were like, hey, how come restaurants and malls can open and shopping stores can open, but I have these strict limits, my house of worship can't open, right? And the Chief Justice wrote a significant opinion. Probably, I'm not exaggerating, it's probably one of the most important opinions you'll ever write, because it basically put on ice every single lower court challenge. It basically said, we're going to defer. The courts are not going to intervene and grant injunctions to block these COVID orders. The case was 5-4, my friends. Justice Kavanaugh had a dissent. Justice Alito was in dissent. Justice Thomas was in dissent. Justice Gorsuch was in dissent. And they were like, these are serious free exercise violations. How can we just sit by idly? But I'll tell you, I'm actually litigating one of these cases with the Beckett Fund. I'm in a group called the Jewish Coalition for Religious Liberty. And we just keep losing. Because all they say is, John Roberts, South Bay. Like, this was probably the most significant decision Roberts wrote, I don't know the decade, but it's up there. Because had the 5-4 come out the other way, the approach of this country to COVID would have had to change. It would have an immediate impact on how all 50 states address the COVID situation. And they would have had to create carve-outs for churches if they had gone the other way. So, I mean, this was a big deal that he wrote this opinion. All right, and that's May. We move on to June of 2020. It feels like forever ago. It was only 4 or 5 months ago. And we start getting decisions. The first major sign that something was up came on Monday, June 15th. In the span of 30 minutes, the court handed 3 defeats to conservatives. This was a very bad day. June 15th, never forget it. First, the court denied review in 10 gun cases. There were 10 Second Amendment cases that were floating in the docket. And we were hoping that one of these would get granted because Justice Kavanaugh said we have all these other cases. We have these 10 cases, right? All 10 were denied. Only Justices Thomas and Kavanaugh dissented from the denial of cert. That was a signal that John Roberts was not interested in guns. Because if you do the math, it's only Roberts. He did not want a gun case. Guess what? He's not the 5th vote anymore. Okay, move on. Second, the court denied review in President Trump's sanctuary challenge. Trump had challenged California's sanctuary laws. There was not even a denial of cert from those. Third, we get to the Bostock case. And Justice Gorsuch wrote the majority opinion. And he ruled that the Civil Rights Act of 1964 has always prohibited LGBT discrimination. Not just that, it's sort of an evolving standard. This was always the rule. We were just all too dumb to see it. Just none of us were smart enough to see what he sees. And the people in 1964 should have known better. That anyone reading this statute would understand in 1964 what's going on. I can do an entire hour talking on Bostock. I won't. I can't. It'll make me angry again. But that's the decision. I called Monday, June 15th, Blue Monday, because it was like this onslaught of just defeat for conservatives on an apparently conservative court. It would get worse. On Thursday, 3 days later, the court decided the DACA case. And here, Chief Justice Roberts cast the deciding vote with the 4 liberals. And they held that President Trump failed to comply with the Administrative Procedure Act when winding down the DACA policy. And Roberts said, well, on remand, maybe you can consider another rationale. Which is basically saying, let the next president figure this out, which looks like to be like Joe Biden now. Because there was no way Trump could reanimate the rescission in a few months. It couldn't be done. It would take too long to do. So I think Roberts like, screw it, just punt to Biden, see what happens then. And indeed, President Biden, I'm sure, will repeal the rescission. Now, fun fact, the repeal of the rescission itself is subject to the APA. So the litigation will be, did President Biden properly repeal President Trump's repeal of President Obama's DACA? You see the madness of John Roberts, right? We now have 3 presidents who have tried to enact and rescind and enact the same executive policy, and all 3 of those are still subject to review. After almost a decade, it's madness, right? It's insane. But this is what the chief does. He just keeps kicking the can down the road, hoping someone else can clean up his mess. See Pennsylvania. I think that he kicked the can far enough he won't have to clean up the mess there. It's looking like it won't matter. But that's the policy. Keep kicking the can down the road. Blue Monday had turned into Blue Week. And soon the month would become Blue June. The next week, the court decided June Medical versus Russo, the Louisiana abortion case. And once again, who else? Hail to the chief. John Roberts decided the cast a deciding vote in the abortion case. And here's the rub. Roberts voted to uphold the abortion law in stare decisis, even though he argued that the precedent was wrong. So he's basically saying, maybe in the future I'll say some other abortion laws invalid, they'll say some other abortion laws valid, but not going to do it here because Louisiana's law is too similar to the Texas law, which have been upheld have been set aside a few years earlier. This opinion caused so much confusion, right? If a decision is wrong, and it's only like 3 or 4 years old, how are you standing by it to uphold the law? And Roberts says, well, stare decisis. He's trying to set a point. Again, he ain't the 5th vote anymore. So I don't know where he falls in this going forward, and I'll get to Roberts in abortion in a few moments. We're not done yet with Blue June. The next case was a bit of a blip. The Supreme Court declared the structure of the CFPB unconstitutional. Victory for conservatives? Perhaps. But the upshot is now President Biden can fire President Trump's director. So, this was a short-lived victory if there even was one, right? The agency stays exactly the same. Now the incumbent president can insult whoever he wants. So, yay, separation of powers. The final case of the June sitting was actually a victory for conservatives. This was a sound victory called Espinoza versus Montana Department of Revenue. This case arose from Montana. Montana had what was called a Blaine Amendment on its books. What's a Blaine Amendment? It's a provision that bars funding of private education, private religious education. It was named after Senator James Blaine of Maine, who was a bit of a racist, and he didn't like Catholics either. And these amendments have been in the books forever. The Maine one, though, had, I think, been ratified in the 1970s, so it was more recent. But the court held that these sorts of provisions are unconstitutional. They violate the Free Exercise Clause. As a result, states would have to reconsider their policies to stop funding to religious schools. Will this decision really make much of an impact? I'm not so sure. There was a First Circuit decision a few weeks ago. Judge Barron wrote it, joined by Justice David Souter, who's apparently still kicking around on the circuit courts, which said, well, the schools can't deny funding for religious status, but they can deny funding for religious uses. So basically, all these amendments will be exactly the same. So this huge decision, I think, will probably have very little play. Right? When liberals win a case, they win big league, right? They win gay marriage, boom, nationwide. They win abortion, boom, nationwide. When conservatives win cases, we get like a little drip, 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 drip. Oh, yeah, we keep a gun at the home in a lockbox, right? Oh, yippee, we can, get, a very small amount of funding for religious schools. Oh, wow, the Little Sisters of the Poor can litigate for 9 years, get nothing for it, right? Just the sorts of victories the left get in case are just significant. Oh, no more death penalty. Great. We can't execute under 18. Good. With us, it's just sort of like, all right, the world looks the same. The CFPB is unconstitutional, but all right, it's still there, right? So this is our world. We get minor victories, which is why it makes me so angry. It's like, oh, we need to pack the core of these conservative victories. Which conservative victories? My God, they're so trivial, right? They are so minimal in the grand scheme of things. Now, Bush v. Gore. Okay, I'll give you that one, right? That might be a big one, although I think Bush would have won anyway if you do the actual count. Citizens United. I think the left spent more money this year than conservatives did. They've benefited plenty from Citizens United. Shelby County is maybe an outlier because the Voting Rights Act was significant, although the lower courts have basically used what's called Section 2, the bail-in procedure, to treat the states as if they're still under the Voting Rights Act. So, the biggest conservative victories have had almost no impact on our country. They've been minimal, just really trivial. Anyway. So I know it's a bit of a rant, but whenever I hear about court packs, it's like, oh, come on, get a grip, right? In Heller at the time, 49 states guaranteed a right to bear arms in the home. 49. So one state didn't. Okay, right? Good, right? So you affected the law in one state. That's pretty, trivial. All right, rant over. Okay. June comes to a close, but we're not done yet. We still have July. And the court had to go into overtime. The first case will prove very significant, which was Chiafalo versus Washington. This case involved the so-called faithless electors. Lawrence Lessig, a professor at Harvard, had litigated for some time about whether the state can force an elector to cast a vote against his will. So let's say an elector doesn't want to vote for Donald Trump, he wants to vote for Colin Powell, right? Can he do that? The court held that, yes, the state can, how do we very carefully describe this? The state can penalize and not use a faithless vote, right? The exact rationale is actually kind of fuzzy, but people don't have the sort of free will that Lessig wanted. Query, what happens if Joe Biden gets exactly 270 electoral votes and Donald Trump persuades someone to go rogue and vote faithless? Biden may wind up with 270. I haven't checked the numbers in the last half hour, but it's 270 is actually the realm of possibility for him. Exactly 270. Oh boy. The next case involves the Little Sisters. The Little Sisters win, but not really. The first round of challenges was turned away, but the court remands, and they have to go to determine whether President Trump's policy is arbitrary and capricious. This is like the eighth circle of hell for the Little Sisters. APA review. They're not done, though. In January, Biden wins, which looks like what's going to happen at this point. The policy will be rescinded, and we'll have to again litigate all over again about what the policy should be. So the Little Sisters will basically be in court for almost a decade, trying to get a resolution of a case. It's unfair. This is not how litigation should work. I know the chief likes to be a minimalist, but he just drags out suffering, and for a bunch of nuns, just resolve the damn case already. Get it over with. The third case was a bit of a sleeping horse, which might actually be a microaggression, about Indian law. McGurthy, Oklahoma. Justice Gorsuch, who has a thing for Indian law, he has a kick because he's a Westerner, I suppose, found that much of eastern Oklahoma belongs to 5 Indian tribes. Look, this is a huge decision for the state. The Indian tribe will now want to have taxation on all the oil revenue. They want to have taxation on liquor, right? They're going to want revenue. And this is going to make the eastern part of Oklahoma a very, very difficult place to govern. Gorsuch's like, who cares, right? We don't look at what Congress intended, we look at their words, right? This is Gorsuch's literalism, as Kavanaugh calls it. It's textualism run amok. I don't know what's gotten into his head. I worry about him. And I think the signal is he's too damn sure of himself, right? And you see this in a lot of his opinions. He says, this case is easy. This case is simple. No, it's not. A case gets to the Supreme Court because it's hard. And I think he lacks humility. He thinks he's humble, but he evinces this haughty arrogance that he knows what no one else knows, that for 50 years the Civil Rights Act was clear. Just you're all too dumb to see it. And that attitude will not serve him well in the long run. I was optimistic about him, but between Bostock and McGirt, I have serious doubts about his temperament. If that's how he approaches the law, that everyone else is just an idiot, he can see what no one else can see, and he's getting played. He's just going to keep getting played, and he won't see what's right in front of him. Maybe he can redeem himself. Maybe Justice Barrett, a good scout mom, can sort of have a talk to him. Give him a one-on-one, say, Neil, have some cookies, right? But he just needs a talking to, because this is really dangerous. I mean, Kavanaugh. I'm not a Kavanaugh fan, but Kavanaugh destroyed Gorsuch in the Bostock case. Go read Kavanaugh's dissent. It was brilliant. I think that was the best thing Brett's written on the court, and I don't say that lightly. I think that actually his opinion in Calvary Chapel is a religious liberty case, but those two, I mean. Kavanaugh just demolished Gorsuch, and Gorsuch had no response. He couldn't, because he had convinced himself he's right, and he was unwilling to revisit his own belief, which is dangerous. You should always be willing to admit if you're wrong. I'm happy to admit that I'm wrong sometimes. Ginsburg would always say that when Scalia had a fiery dissent, she liked it because it helped her hone her arguments. Right? She looked to Scalia's dissent to make her arguments stronger, and Neil doesn't. He sort of just deflects it like Teflon, and he ain't Teflon Don. Next, the final big case of the term involved tax returns, right? And the court sort of split the baby, which is how Gorsuch treated Oklahoma. The court ruled that the House representatives could not request the tax returns, but the New York District Attorney could. And at the time, there was still some thinking that maybe the returns would come out before the election. Well, my friends, election came, election went, no tax returns. So I guess no one cares now. Does no one actually care what's in them at this point? We just go away and forget about them. Maybe we'll find Hillary's emails next to the tax. I don't know. It seems just no one cares anymore. All right. Well, that was the end of the term. No, just kidding. Not even close. In July, they had a flurry. Oh my goodness, a flurry of activity. They upheld federal executions, which Attorney General Barr tried to resume, and which Attorney General, let's see. Oh, God, who's it going to be? Elizabeth Warren? Sheldon Whitehouse? Oh, Lord, help us. Who? Let me actually take a step back. If the Republicans had 51 or 52 senators, I can see the Senate not confirming an AG if he tries to appoint like someone radical. That's what I'm thinking. A senator might actually be a good idea. I think they may actually vote down an Attorney General nominee if he goes too radical. Javier Becerra, right, from California. If he tries to really go left, Doug Jones, that's a fascinating suggestion. That's actually really smart. I could get behind that. Yeah, that's actually not bad. Former private citizen Doug Jones, as I like to say now. That's actually plausible. Or Chris Coons, maybe from Delaware, that might be a plausible one. But I mean, if he goes, like Letitia James from New York or Javier Becerra from California, I don't think it's confirmed through the Republican Senate. So I think you have to be very careful. What else happened in July? There was an order that blocked former felons from voting in Florida. There was another case involving religious liberty, Calvary Chapel versus Sisolak. Again, the court split 5-4. In Nevada, you can have a casino without limits, but no limits on people or slots, right? But on churches, they had strict limits. There was another case from Idaho involving signatures. There was a case that allowed Donald Trump to build the wall. Does the wall come down, or did they actually tear it down, or just was never built in the first place? I don't know. If you build a wall and no one sees it, does it even make a sound? I have no idea. And then with the leaks, right? We had all these leaks from the Supreme Court. Apparently, the Supreme Court is now a sieve that everything comes out. And that brings us to August. August kind of slowed down. Things were a little bit more calm, and we were sort of getting ready for the term. And then, September 17th came, which is my favorite day of the calendar, which is Constitution Day. It was the day the Constitution was signed. And Justice Ginsburg was supposed to receive a medal at the National Constitution Center in Philadelphia on September 17th, but she wasn't there. It's like, I wonder what happened. And in fact, Justice Gorsuch, I believe, went in her stead to accept it, or went on Zoom to accept the medal. I'm like, why is Ginsburg not there? I mean, can't you turn on Zoom like anyone else? We're all sitting in our pajamas, suit top, pajama bottoms. I'm sure we all are right now. I am. It's true. I used to wear a full suit on camera. I was like, screw this, I'm done with this. So yeah, I'm comfy, guys. Don't worry. But RBG wasn't there, and it turns out at that point she was on her last legs, and she passed suddenly on September 18th, which was the holiday of Rosh Hashanah, the Jewish holiday. And I remember I was about to sit down for dinner, and I got one of those text alerts like, Justice Ginsburg died. I'm like, what? And I was like, wow. I disagreed with her vigorously, but I very much respected her. I think she made some terrible decisions with her comments off the bench, but her pre-court life was just remarkable. Remarkable life lived for more than 8 decades. And immediately, I felt this flashback to Justice Scalia's passing in 2016. We were in an election year. And of course, we all know what happened then. The Republicans said we're going to keep the seat open for the next president. And of course, what happened here is the exact opposite. They said, well, screw it, we're confirming someone. And it seemed almost within minutes, the Republicans coalesced on a strategy that they're going to fill the seat as soon as possible. Whether before or after the election, they weren't sure. But I think in hindsight, they probably made the right call. Trying to fill it now would be really tough because Trump has basically lost the election. So I think Mitch made the right call. And they said, we're going to confirm it before the election. And at that point, President Trump pretended to have a process where he said, we're considering all these people, but he wasn't. It was, just signaled the Amy Coney Barrett theme music. She was coming out of that hallway anytime. And President Trump nominated Justice Barrett at this lovely Rose Garden ceremony, which a lot of people I know got sick from. It's remarkable. This stuff happens. Or just that's whatever. Nothing. It happened last month. And they nominated Justice Barrett. She was the runner-up for the Kavanaugh seat. The seat went to Kavanaugh. I think she hadn't been a judge long enough. And, people said that Trump was saving her. They were saving her for the Ginsburg seat, which could have never arisen. I mean, now in hindsight, if Ginsburg had survived and retired in January of 2021, that seat would have been gone. It would have been filled by Joe Biden with, Nina Pillard or, Leandra Kruger or whoever else you want to pick. Andrew Brown Jackson, whoever you want to pick for that seat. He could have put someone in. Patty Millett, whoever it is, who would put someone else in that seat. But now it's for the next 40 years, ACB. And that matters, right? Almost immediately after the Ginsburg seat was filled, the Democrats started talking about court reform and court packing. And Joe Biden kept saying, we'll look at court reform. We'll have a committee, we'll have a commission. And there's some evidence that the decision to talk about court packing before the election may have actually turned away some moderate voters. And in Iowa and North Carolina, there's evidence that both Joni Ernst and Tillis benefited from the court packing. They ran ads on it. So for all we know, the court packing chatter helped keep the Senate for the Republicans. I mean, we can never prove it. You never know. But it's very likely that it did. So now let's map this out one of two ways. Option A is Republicans have 51, 52, or 53 seats, which somewhere in that range is probably feasible. Court packing is off the table. The filibuster remains. The lower courts are not expanding. It's possible Mitch might not even bring any votes for judges, as all the judges will sit empty. We'll have no confirmations for 2 years. I think it's not quite likely, but it's possible. In the event that the Dems get 50 plus 1, which is I think the best they can do at this point, 50 tie plus Kamala Harris casts the tie-breaking vote. They're not limiting the filibuster with a 50 vote majority. It's not going to happen. They can't. They're not expanding the court. So I hope court packing is off the table for at least a couple of years. Maybe you think I'm wrong, maybe I'm being naive, but I think just with the numbers now, there's just not going to be the votes to limit the filibuster, and they're not expanding the courts. So I think at least the next 2 years, and probably for 4, court packing is off the table. So I think we're going to be stuck with this current 9 for some time. Justice Breyer might retire, in which case, but does Breyer retire if it's 50+1, or does Breyer retire if it's 53 Republican? Because they can just keep the seat open for 2 years or 4 years, which I think they would probably do. They don't need Breyer's vote. I think they keep the seat open, so I think Breyer is going to have to hang in there as long as he can. I hope he does. I like Breyer. He's a good guy. I don't think he gets enough credit. He's a very good justice. He's just not getting enough credit. All right, but we now have a court with 6 Republican justices and 3 Democratic justices. Is this a 6-3 conservative court? Not really. I think Roberts will still try and do what he's going to do. But, and here's the big but, the Chief Justice likes to be moderate, but he also likes to be in charge. And I think the Chief will have to moderate to the right. And let me explain why. I don't think John Roberts wants to write dissents for the next 3 decades. I think he has no interest in writing dissents, right? I've looked into this. I can't think of a Chief Justice who's always in dissent. Maybe Melville Fuller in a couple of cases, but just not many. Usually the Chiefs are in control. And to the extent that the 5 conservatives flanked Roberts' right, he will vote with them so he controls the opinion. Now, if Roberts is too moderate, they can fracture off and let Justice Thomas assign the majority. Oh, this is good, though. Justice Thomas will assign a lot of 5-4s. I mean, that never happened before. We have CT assign 5-4 opinions, which is significant. Now, where does Justice Barrett fall? I don't want to be too optimistic because I think I was a little too giddy about Gorsuch, but I am very optimistic about Justice Barrett. She was a law professor like myself, so I know where she's coming from. I think she could rise to the level of Scalia, and let me explain why. Justice Scalia's impact was not only writing opinions, although his opinions were delightful. Scalia brought his message to the masses. He would go speak to college campuses. He would go to civic groups. He would go speak to trade shows. He would go on TV. He would do things that had a connection to people. And people who hated him loved him. And I think Barrett has that same sort of charisma. The Democrats could not lay a finger on her. She was so damn likable. They tried. They did not lay a fingerprint on the woman. Nothing they had stuck. They tried and they stopped. I think Barrett can bring originalism and constitutionalism to an audience that has never been seen before. We've never had a conservative female justice. Don't tell me Justice O'Connor. She was a moderate. We've never had a woman who can actually convey this, right? I think maybe I see some women on this call. I think she's going to inspire an entire generation of conservative women that you can be a conservative, you can have a family, you can be a member of your religious faith, and you can succeed in life. And I think that's an important message to convey, even beyond the Supreme Court. This is just a motivation, right? They keep saying she's the first justice with school-age kids. Why are they saying that? Because we're taught that if you want to be a successful woman, you can't have kids. You have to put your career first. RBG, by the time she was a judge, her kids were already adults, and Kagan and Sotomayor don't have any children, right? I think this is a good model. So when we can finally go back to visiting college campuses, I think Amy's going to pack the house in ways that Kavanaugh sure as hell can't, because he's a leper right now. He can't go to any college campuses. He can't look. He'll be protested. And Gorsuch just, I've seen him speak publicly. He just has this very sterile effect. He just has this very sterile demeanor. He's a good speaker, but it just feels forced and artificial. I'm looking like a surgeon talking. I think Amy has the charisma to really elevate to the next level. I don't know. Maybe I'll come back to your chapter next and say, I was wrong. She's just another, Kennedy. I don't think so. And I think it's going to be hard for the chief to pull his shenanigans because I think she can call him on it. Because I think she's pretty principled. And I don't think she's going to bend and sway whichever way the winds blow. I think she's willing to take a stand. And I'll just give you an example. Yesterday, the court heard the Fulton case. This is about the Philadelphia city government. And the facts are complicated. I'm going to screw up the facts if I try and summarize it. But there's a Catholic social services that had evaluated couples for foster care. And the Catholic group will not evaluate a gay couple. And that's the basis of the challenge. I won't go into the facts more because they're complicated. And Justice Barrett was asking point blank, are we overruling Smith or not, right? If we overrule Smith, what do we replace with? Is it Sherbert? She's asking questions about third-party harm. Like, these are really good questions. She's coming right off the bat. So she's showing good things so far. And, maybe she'll disappoint me. I couldn't say. But so far, so good. And if the Dems don't have the votes for court packing, I think the restraints in the court lifted. They're not going to be petrified of their shadow every day, especially if the chief is not in control anymore. So I think you may actually get a fairly conservative term this year in ways we haven't seen before. Okay, I'm going to stop now and welcome questions either in the chat or you can raise your blue hands, and happy to engage. Well, it's almost an hour. That's pretty good. Not bad.
All right, that was great. Thank you very much. Does anyone have any questions?
Yes, Nitin, go ahead.
Well, first, thanks for speaking to us. This is really interesting, and I enjoyed hearing from you. My question is in regards to should Biden, have a kind of have a Supreme Court opening if Justice Breyer was to retire. I guess in the event that we do have 52 seats in the Senate held by Republicans, who would you say is kind of like a reasonable pick that Biden could put forward that Republicans in good faith could vote to confirm?
Merrick Garland. That would be the ultimate McConnell troll. Yeah.
That was my thought too.
McConnell said, "You know what, Judge Garland, we treated you poorly. We're going to give you a hearing." Merrick Garland, you don't have to file your paperwork. Just keep your same paperwork. We'll take your paperwork from 2016 and we'll give you a hearing. That would be the ultimate troll. Look, if Biden would pick Merrick Garland, I think there would be a coup in his party. Like, look, it has to be a woman of color. He said that several times. So Leandra Kruger, Judge Ketanji Brown Jackson in D.C., Stacey Abrams. There's a list that exists somewhere in the DNC. It's not a public list, but I'm sure there's a list that exists. If they nominate Leandra Kruger, are there enough votes to filibuster? Right? There's no filibuster anymore. You can't filibuster a judge. So can Judge Kruger get through? Possibly. One other thought, which I need to write about, is a Senate Judiciary Committee. I think the SJC votes down Judge Kruger. Or they just vote down Judge Brown Jackson. They just vote her down, and she never gets a floor vote. Because the SJC is a lot more conservative, right? Susan Collins does not sit in the committee. Mitt Romney is not in the Judiciary Committee. So I think Lindsey Graham would just do the dirty work and vote them down. Give them a hearing and vote them down. And that would just elevate the next conflict. And they say, you know what? Send us Merrick Garland. We'll confirm him. Or they can say, you know what? We presumptively, we passed the resolution of the Senate approving of Judge Merrick Garland. We just passed a resolution. We approved Judge Garland. Just send him to us. We'll give you consent. No hearing. Go Merrick Garland. What is he? He's got to be in his 70s now, right, Garland? I mean, he's got to be up there. Poor Merrick Garland. I feel bad for the guy. I mean, just all things considered, he's kind of a punchline now, right? But, go back and watch the speech he gave with Obama in the Rose Garden without COVID, right? The Rose Garden 2016. It was a moving speech. I do feel for the guy. I always see a punchline now. I joke, your persona on Garland, right? Garland. Or you pick one of the more senior Clinton judges. Maybe Diane Wood might be a good compromise from the Seventh Circuit in Chicago. I mean, she's got to be in her 70s, but Ginsburg was also in her late 60s at the time. Who else might they pick? I don't know. I have to think about it. I mean, I think Garland, I think, have to be one of the more senior Clinton judges. Wood is a chief judge of the Seventh Circuit. I mean, what if Mitch McConnell said, all right, President Biden, here's a list of 5 judges we'd pick. Pick one of them. And he gets the entire caucus behind it. I wrote an article years ago called Advice Before Consent, where I suggested that the Senate should actually vote on judges before the nomination is made and say, here's the 5 people you can pick from this list. Any of these will come through our caucus. No problems. And I think that, I'm going to have to write that now. I think that would be a baller move from McConnell. I think it'll be Diane Wood, maybe Merrick Garland. There's maybe Judge Fletcher, maybe in the Ninth Circuit. She's got to be pretty old now. Who else might there be? Yeah, there's a handful. There's not many.
How do you feel about Judge Srinivasan on the DC?
Oh, Judge Sri. Well, Judge Sri had a little PR move recently. You may recall that Judge Griffith had retired, had announced, this is actually kind of bad. Judge Griffith was a judge in the D.C. Circuit. He was a W nominee. And the backstory is now as public is his wife was quite ill. And his plan was to retire the day he took, to retire the day he was eligible to retire with pension, right? There's a formula, and a specific date he was going to be eligible to retire with full pension for life. And everyone knew this, right? So one of these left-wing groups was a Demand Justice. One of these left-wing groups put in a complaint suggesting that he timed his retirement to give Trump another vacancy. The allegations were never real, right? This complaint should have just been dismissed outright. But Judge Sri, who's the chief judge, Srinivasan, he goes by Sri, I'm sorry. That's what people call him. I'm not trying to be diminutive. That he goes by Sri. But Judge Srinivasan allowed the complaint to ride. And I think the Chief Justice had to step in and say, this is not going anywhere. I don't want this going the wrong way, but I think I'm on good ground. Had Srinivasan shot down that complaint, I think he'd been taken off the short list. And I can't help but think that personal aspirations got in the way. And I realize that what I'm saying now is very bad, but that should not have gone forward. The Chief Judge should have been known enough about the situation to not allow this complaint to go forward. I think you had this sort of talent show on the D.C. Circuit of all the judges wanting the short list. And all these en banc votes, right, that were granted, had any of them not voted to grant en banc in any of these Trump cases, they would have been off the list. So look, you have Judge Pillard, you have Judge Millett, you have Judge Srinivasan. I think they're all on the short list. And this is not just It's not just a Democratic thing. Back in the day, John Roberts was on the D.C. Circuit, and after Rehnquist died, he rushed out this opinion that was the most pro-Guantanamo opinion ever. He rushed it out, and it was very obvious he was auditioning, right? Judge Kavanaugh, who was in the D.C. Circuit, ruled in a case about abortion called Garza, about these underage immigrants seeking abortions, and man, was his opinion fiery. He was auditioning, right? This is a well-known phenomenon that circuit judges in the shortlist audition for the Supreme Court. And Zoom is rebooting. There I am. Hello, everyone. I'm back.
Welcome back.
I have this dread whenever my connection drops. It's just like this awful thing. But anyway, my point is, judges audition for the Supreme Court. I think Judge Srinivasan was auditioning with that, and I'm not a fan of that sort of move, but they all do it. Kavanaugh did it. And this whole D.C. Circuit judges, they all think they're on the Supreme Court material. Kavanaugh did it. Roberts did it. Sri did it. I think that's what they do. But yeah, if I was Mitch, I would say, here's a list of 5 people we'd put on the court. Pick one. And then let's see what Biden does. Merrick Garland, Dan Wood, I think of the other rest of the list. Got to be in their 60s and late 70s. It'd have to be, basically someone Clarence Thomas's age would be the nominee. All right. Other questions from the students?
Yeah, I have one question. Unless anyone else has another question before we wrap it up.
I have a question as well, but you go first.
Please.
Okay, well, I'm intrigued by this thing you're mentioning about the court using phones instead of Zoom. Now, I wonder why they might have chosen to do that, because it seems like that caused a million problems. And I'm just interested in the behind the scenes of the court. Do you have any insight on that?
Oh, why the court won't need Zoom?
Yeah, why would they choose to use sort of an antiquated technology when there's better things that are just as readily available?
All right, so the court isn't actually live streaming the arguments, right? They're just using telephone, and they're giving C-SPAN an opportunity to listen to the arguments, right? I think the court is afraid that with Zoom, they would need to sort of put on the backdrops and the production and the lighting. This allows them to do it very low tech. And the court just is very resistant to change. The other issue is that if the court allows cameras for Zoom, the arguments for cameras become very strong if they ever go back in person, which I think they'll have to eventually. So they're happy to just do telephonic, which I didn't know what they were going to do. I thought they might just cancel arguments and cite on the papers, which they can do. There's no like requirement to have arguments on in person. But look, I've long had a fear that the live streaming of arguments would be a bad idea. That people would use them inappropriately. That there would be, the news media would slice them up. We've had no issues now for almost 6 months. The concern in my mind now is not the live stream of the arguments, it's of disruptions, right? If you notice, the Kavanaugh hearings had all these disruptions, but the Barrett hearings had none. Why? There was no one allowed in the room. So maybe the solution is to just only have live cameras and no public access, right? You just don't let people off the street to the arguments, or you restrict access to tickets, which I've written about. I think people disrupting is a bigger concern about the live stream. Go ahead, Brendan.
Hi, Richard. Thank you for your talk again. So I just was curious, what cases like this upcoming term should we really pay attention to that are most likely to be the most important cases of the term?
I thought Fulton would be big, but after reading the arguments, I think it's going to be pretty narrow. It's a very messy case, and the facts are complicated. I think we're going to have a very narrow ruling. I filed an amicus brief in the ACA case as well, although I don't think it's going to go very far. I think there's a case involving, let's see. I think there's a case involving, it's the FHFA, the Fair Housing Finance Administration. I always forget the acronym. It's a follow-up to Seal of Law, which involves the Appointments Clause. That might be big. We don't have an abortion case in the docket yet, but there are several percolating that might come up about whether June Medical, in fact, overruled Holman's Health. I think that's a significant issue. Of course, you might have an election case, although at this point, looking at 6:06 p.m. on the 2 days after the election, looks like we don't have any election cases. I think this term might be a little bit sleepy. I mean, it might blow up quicker after last year, but I think we have a lot of cases that say, dismissed as moot, remand, Munsingware. Munsingware, if you don't know, is a case that if a case becomes moot on appeal, you just vacate the lower court decision with some exceptions. So I think this case might be a little bit sleepy. I hope so, at least.
Yeah, I think sleepy would be good after this year.
Last year was painful. My God, just one after the other. But I think, I don't think we'll get any blockbusters. We have stuff in the census that's on the calendar, although that, if Biden wins, I think the census issue kind of just fades away because he'll just run the census normally. I'm looking at the list of cases, there's not much that's huge.
Okay, well, does anyone else have any other questions? If not, we are past the hour, so maybe we should wrap it up and give Professor Blackman a round of applause.
Thank you so much. Thank you so much, everyone. I hope next year I'm able to visit you all in person. If I don't, I'm sure I'll see you around the circuit. Thank you so much.
Definitely. Thank you very much, everyone.
Thank you.
Especially Professor Black.
Thank you.
Thanks.